Innocent until proven guilty, or is that now the other way round? Lots of people have tagged me in a post by the Home Office, which has now been picked up by Lee Anderson, who's written to the Home Office, and a letter of which I'll go into some detail about in this video. And if you'd like a fresh, neutral, brutal, unbiased approach to what's really going on here, an analysis of the law from a practicing barrister, please do consider subscribing to my channel for a fresh alternative from the mainstream media and things that they might not tell you about. Because the post in question by the Home Office said these criminals, referring to those that have been arrested with regard to the recent riots, these criminals will face the full force of the law. And it says more than 1,000 arrests related to public disorder. Now, obviously the problem there is that they've been referred to as criminals when they may have a previous criminal history, but to bring that up might prejudice a case anyway, which is always why when someone's going on trial for something, it's what we call bad character evidence. And if it's a previous offence which may relate or may be of the same nature as the current offence charged, then it may be admissible because it may show propensity to commit that kind of offence. Whereas, let's say one offence was for drugs and the other one was for theft, and they're completely unrelated, both in the nature, the circumstances, the facts and nexus, the time of the offences and so on, then one may be excluded as being prejudicial if the case went to a jury trial. Why is that? Well, when you go to court and you have a jury, they hear the case by the prosecution. And I always say when you hear the full case by the prosecution, you should be pretty much convinced that they are guilty, that they did it, just on the prosecution case. But then you hear the defence case, and then you should be equally convinced that they didn't do it, that they are innocent, and that there's a very good defence, or they weren't there, or whatever the excuse is. Whether it's a valid excuse or not, you should be equally convinced just on the defence case that they are, in fact, not guilty. But that's where the balancing point comes in. And very often that tipping point may be just something, for example, a previous conviction. Now, if it's a previous conviction for the same offence, it doesn't mean that they are guilty of this one, but it's more likely. And so that might be a tipping point for a jury. And so it would be prejudicial if somebody had a previous drug conviction that somehow came out. And there are ways that it can come out regardless. So, for example, if it was initially ruled as inadmissible as being prejudicial, because it would be such that it would have an unfair effect on the proceedings and thus excluded from evidence, therefore the jury doesn't hear about it, at least until sentencing and such like, when they might hear the previous convictions list. But let's say that the defence advocates attack the credibility and good nature of a prosecution witness, and that's somewhat unfair. Then if they are reducing bad character of one of their witnesses, it's only then fair that the prosecution might come back and say, well, actually, now we want to reduce the bad character evidence of this defendant, even though it was originally ruled inadmissible. Now, that's a very, very broad overview from someone who doesn't specialise in crime, but that is a very broad overview on how that works. Now, the problem with this tweet, obviously, is it says these criminals will face the full force of the law. Now, whilst it says over 1,000, more than 1,000 have been arrested, if those are then going to trial, the question then is, well, will a jury remember this post and will they think, they are criminals and therefore prejudice the case? Now, because it's such a large group and it's over 1,000 of them, probably not is the answer to that question, but it does raise a very important question and a very important point. And for me, it's very much more a reputational management approach. So Lee Anderson posted, innocent until proven guilty. Well, it appears not since Labour took charge. Check this tweet from the Home Office sent out last week, which in my opinion is disgraceful. Then check my letter to the Home Secretary. We cannot allow the state to assume anyone's guilt until they've had a fair trial. They are not criminals until they've been found guilty. Hopefully our judges will see through this. Now, obviously, given everything that I've explained as to why it would be prejudicial, even if they did have a previous conviction and they are a criminal when they're arrested for this offence, it may still be prejudicial and would still be wrong. As I say, with a group of over 1,000, probably not too much of an issue, but it may still cause an issue. It still very much raises a question. if I were defending a case like that, it would be something that you would consider. The letter reads, I'm writing to raise my concern about a recent comment posted by the Home Office on X, formerly Twitter, which was posted on the 15th of August. Your department tweeted that more than 1,000 arrests have been made related to public disorder, and that these criminals, in quotes, will face the full force of the law. Can you please provide answers to the following questions? Can you confirm that these 1,000+ individuals are known to have criminal records? If the answer is yes, why has this check been done prior to them appearing in court and then tweeted about? Going forward, will those arrested regardless of the offence have their criminal records checked by the Home Office and have this information posted on X? How will this not prejudice their trial? And if the answer is no, then the individuals have not had their criminal records checked prior to appearing in court. Why has the Home Office referred to them as criminals? At best, this is inappropriate and unprofessional. At worst, it appears to be possible contempt of court, which is something I'll come back to in a moment. I would like the reasons outlining to me if you do not agree with my concerns. Please assure me that we do not now have a two-tier justice system as well as two-tier policing. And so, just to briefly touch on the contempt of court point, it would be contempt of court to do something that might prejudice ongoing proceedings. And so, with obvious ongoing proceedings, if someone has been arrested, then that proceeding is live because they've been arrested for it. And then obviously all the way through the trial, doing something to affect the proceedings could well be contempt of court. And it's worth bearing in mind as well that the government's own guidance on this to the public is that publicly commenting on a court case, which is anything from the point of arrest because proceedings are live at that point, you should not say whether you think a person is guilty or innocent, refer to someone's previous convictions, name someone the judge is allowed to be anonymous even if you did not know this. So even if you didn't know that the judge has granted anonymity and you name them, that could still amount to contempt of court, although the judge might be a bit more lenient if you really didn't know. But that's obviously not a safe place to be. You shouldn't name victims, witnesses, or offenders under 18. You shouldn't name sex crime victims, and you shouldn't share any evidence or facts about a case that the judge has said cannot be made public. And just a point on reporting and contempt of court for reporting. Reporting should be fair and accurate, and that includes the stage at which we are at. And our learned friend Alan Robertshaw's got some really interesting points on this as well over on Art of Law. I will link that in the description below. There's just another take on it with a few more things that I'll probably miss out or get wrong, which he will probably get equally wrong or correct me on. And the reporting of a case bit is really interesting and really important, because if it's live and contemporaneous at the same time as the prosecution is going on, and you can report all of that, if you then stop and from what you've reported it really looks like they are guilty, because remember what I said, if you watch only or you hear only the prosecution case, you should be convinced that they are guilty. If the case proceeds and in fact they are found not guilty, or even worse for you still doing the reporting, that there's a submission, no case to answer at what we call the halfway point. If the case is then dropped and dismissed, but you've only reported the prosecution case, that can obviously look really bad. And so that could amount to defamation as well. And it could technically amount to contempt of court because you've not accurately reported the full case. So if you were to report all of the case all the way through, then that's fine. And if there's an update, you need to really report that as well. And many newspapers do that by way of an update. But as I say, check out our learned friend Alan Robertshaw's video linked in the description below as well. And so why this is really important is that if any of these cases do go to a jury, the jury obviously need to approach this from a very neutral standpoint. And even the judge will direct the jury to disregard anything that they've seen and heard, and they'll direct the jury not to research the case, not to discuss it with anybody outside of their number, or to consider anything other than the evidence that they hear in court that is presented to them by the prosecution or the defence. And so if they do, which they are likely to see posts like this from the Home Office on X, which at the time of looking at this post here and recording this one post has been viewed 2.5 million times. Now, it doesn't give me a detailed breakdown of the statistics and geographical location of the viewers of this post here. Obviously, it can be viewed worldwide. But the chances are a great deal of the British public, who may end up sitting on a jury for many of these trials, which are likely to go on for some time, because those that are dealt with quickly have likely pleaded guilty, and so they go through the system very quickly, get sentenced very quickly. But those that plead not guilty will end up in a trial, and for the vast majority of them will be going to the Crown Court, because it will be more than a 6-month custodial sentence. So even if they start, which they will start at the Magistrates' Court, they'll be sent to the Crown Court for trial, or at the very least for sentence. But even then, I would imagine anyone pleading not guilty is going to elect Crown Court trial anyway. So the vast majority would probably go to the Crown Court, and therefore the jury may well have seen this post. So are they likely to be prejudiced by having seen this post, just by that word there? The chances are probably not, but as I said, the reason it's really important is that this has to be impartial, and it has to be seen to be impartial as well, which is why I think this is very much, or as much, a reputational management aspect. Because on the one hand, the government has to be very strict in dealing with all of this that's going on. On the other hand, they have to try to manage their reputation, and putting posts out like this, I mean, there are some other posts which are similar, which another one, for example, reads as follows: "Crime never pays, but those who committed violent disorder will." And it's a similar style post that says rioting is up to 10 years prison, violent disorder up to 5 years, and so on. A further similar post says violent disorder facing justice, more than 1,000 arrests, etc. So those are portraying the warning that if you were caught up in any of this, that you'll be arrested, you'll be charged, and you could be facing a prison sentence. But I think where it does possibly cross a line here, certainly in terms of reputation, is by naming them all as criminals. Now, obviously, if they are charged and found guilty or plead guilty, then it's a criminal offence. But until that happens, they are not criminals unless they have a previous criminal history, which shouldn't be researched, at least until they are proceeding through court. And even then, it shouldn't be made public, etc., for all the reasons I've named. So I think this does pose a problem, and I can see a few defence advocates bringing this up. So at the very least, it's a reputational thing. But check out Al's video linked at Art of Law below for another view on that. Let me know your thoughts in the comments, politely and respectfully, please, because this is a democratic discussion about what is really and genuinely happening right now and what is being publicised about it. And so with that, I hope you subscribe for a brutal, raw, honest, open, truthful analysis of the law as I see it on my channel. Please subscribe, and I'll see you next time.